need to look at this without any brain fog, and we need to look at this with great care and scrutiny and intellect and intelligence, right, when we read this, because this is important now for pretty much everything that is happening now, contrary to established law and rights that people have overlooked. Serious things like the ULEZ charges in London, where there's not meant to be any tolls in London due to ancient rights and liberties, when it clearly says all the ancient rights and liberties and then goes to list them all. But let's just, I want to go through this now, right? Because remember, there are 4 clauses of this still in effect. 39 and 40, which the numbers have been changed, but they're known as 39 and 40, which are the legal principles that are in effect. And then we've got clause 13, which is all the ancient liberties of London. And once you find out what they are, all of them are in effect still through Magna Carta. And we'll get on, that's in another complaint to do with the ULEZ charges and the fact that the Blackwall Tunnel doesn't have a toll on it, but we'll get to that later. That's just an example of one of the other important things. Now, clause 1, right? The first clause, which is here, right? But this is, let's just read this opening part, right? Because we need to be really clear on this now when I get into this Charter of Liberties, because you've got to know that there was some laws of Edward the Confessor. There were laws of Edward the Confessor, and there's a collection of various laws which can be researched. I've got them all down and listed. Now, it's the full itinerary is debatable, but how those Edward the Confessor laws are relevant is because the Charter of Liberties, the Charter of Liberties retains the lieges of Edward the Confessor, right? And then the Charters of London retain all of the ancient liberties and laws. So the Charter of Liberties is one of the charters that is retained, right? And I'll prove that the Charter of Liberties retains the laws of Edward the Confessor, and this retains the Charter of Liberties. Magna Carta actually retains the Charter of Liberties. I'll explain why. We'll go through it, and this is only 2 parts because there are only 4 parts still in force. This is important, right? Because you need to have zero brain fog whatsoever. And I'm not talking Mr. Silk or whatever they call him, the most technical, detailed Silk there is. One who is still a practicing solicitor and a judge at the same time, even though you're not supposed to be practicing solicitor and a judge at the same time. And that's another complaint. But right, let's get into this now, right? John, by God's grace, King of England, and they're only just starting to write this now, by the way. At this time, he just put pen to the paper, right? As he's writing, as they're writing this out, King of England, Lord of Ireland, Duke of Normandy, and Quintain, Count of Anjou, and his archbishops, bishops, abbots, earls, barons, justices, foresters, sheriffs, reeves, right? What are reeves? Well, the reeve is the Anglo-Saxon word for the justices, magistrate, judge. In fact, the chief or head judge or magistrate. But this is the Anglo-Saxon word and term. So these are the Anglo-Saxon justices and judges, which many of them are still using the laws of Edward the Confessor, and they're still using the Charter of Liberties, which the Charter of Liberties retains and uses the Anglo-Saxon laws, because in the Charter of Liberties they say, I will restore the laws of Edward, right? Now, the Reeves are the Anglo-Saxon judges who are listed in here. Reeves. This is to Reeves. Reeves are using the Charter of Liberties and Edward the Confessor's laws because the Charter of Liberties retains them and grants them. Reeves, right? Clarity, zero brain fog, right? Officers and all bailiffs and subjects, greeting. Know that for the sake of God and for the salvation of our soul and from the souls of all our forebearers, right? Souls of forebearers, right? For the sake of all the souls of our forebearers, right? Where are the souls of your forebearers? Who are our forebearers? Our ancestors, right? Who are our ancestors and forebearers? Well, they're buried, aren't they? In the tombs and graves. They're buried in the tombs and graves, right? The souls of all our forebearers and heirs to the honour of God and the advancement of the Holy Church and the reform of our kingdom by the council of Venerable Fathers, Stephen Archbishop of Canterbury, Primate of all England, etc., Cardinal of the Royal Roman Church, Archbishop, London, Peter, Winchester, Jocelyn, Bath. So these are all holy people. Holy people. You know what holy people usually associated with churches, burials, graves, churches, holy business, right? William Country goes on, right? Rochester, Benedict Master, blah, blah, blah. I'm skipping this part because I don't need too much brain fog removed, right? Temple in England and the noblemen, William Marshall, Pembroke, the list goes on, right? More people. So that's listing everyone and others of our subjects, right? So it's addressed, the first part is who it's concerned with. So the Reeves are in there. And it's speaking on behalf of the souls of our forebearers, right? This is very, very important. Now, let's get into this, right? We have first of all granted to God, and by this our present charter, confirmed, right? So, what is the present charter, right? Well, it can't be this charter because he hasn't finished writing it. He's only started out in clause 1, right? So, as he's writing this out, okay, our present charter is confirmed. So, at the time of writing this Magna Carta, right, he's written the introduction and who it concerns, and now he's starting to write this charter, which he hasn't even finished writing out yet because he's only on clause 1. He's saying our present charter. You don't have a present charter, right, when you haven't finished it. It's talking about the Charter of Liberties, which retains all the laws of Edward the Confessor, right? Present charter confirmed. It's confirming the Charter of Liberties, right? It's confirming the Charter of Liberties here. For ourselves and our heirs in perpetuity. Well, in perpetuity, when they're buried in their tombs and preserved in perpetuity, I would have thought that the English Church is to be free and to have its full rights and liberties intact. Well, that must be the Charter of Liberties as well, because it's called Liberties. It wouldn't be a Charter of much liberty if it's called the Charter of Liberties. And they've just referred to the present Charter confirmed. It's the Charter of Liberties intact, with those laws of Edward the Confessor. And we wish this to be observed accordingly, as may appear from our having of our true and unconstrained violation before discord arose between us and our barons, granted by our charter, confirm the freedom of elections, which is deemed to be the English Church's very greatest one, and obtained its confirmation by the Pope Innocent, which we will ourselves observe and wish to be observed by our heirs in good faith in perpetuity. Well, that's forever. And we also granted to all the free men of our kingdom, of ourselves and our heirs in perpetuity, all of the following liberties. So it says, and we have also granted the following liberties. Right, well, it follows when he starts to write them out. When he starts to, as follows. I'm in clause 1 now, and I got a pen on the paper, and we are also granting the following liberties. So, as I am now about to enact. So this actually, this is huge. Because when you get people like David Cameron popping up on, Question Time, oh, we've got a Magna Carta question. Magna Carta is confirming the Charter of Liberties. And the Charter of Liberties retains the laws of Edward the Confessor. So this is huge. This is massive. Because this Clause 1 is still law. Clause 1 is still law, as is 39 and 40, and that 13 for London. And London has all its ancient rights and liberties as well. So this is massive. This is huge. And, right, so this is from the Charter of Liberties. This is the Charter of Liberties, and this is number 13. And number 13 says that I restore the law of King Edward and the amendments which my father introduced upon the advice of his barons. So it's the Charter of Liberties is in force, and it also restores the laws of King Edward as well. And in fact, there's actually a law in that Charter of Liberties about barons, which again I find Judge Jeremy Johnson KC seems to gloss over in his Lord Hanningfield representation, because he only seems to cite the only relevant law to be worthy of mention in the 1688 Bill of Rights under illegal prosecutions by the King's Bench, when actually one of the Charter of Liberties clauses in barons is relevant as well and in force, which means that barons can actually be fined and prosecuted. Although the argument in that case was about whether it qualified as casework for Parliament or not, work for Parliament or not. But that's a different argument. The King Edward, King Edward, and it is Edward the Confessor. That's what it is. So, and these are them. This is what is now. You see, now we need to get into. Now we're really getting into. You can't just walk into a court with a lawyer, because this is like specialist now. This is like you need historian. The Saxon laws of Edward the Confessor, the Leges Edwardi Confessoris, they consist of a collection of various laws, right? And that they're recognized as, they're officially recognized as these. These are recognised by historian professionals as the laws of Edward the Confessor. Leges Edwardi Confessoris, right? Leges Henrici Primi, the Textus Raphenis, laws of Athelbert, laws of Othelier and Edric, laws of Wilfrid, laws of William the Conqueror. Well, laws of William the Conqueror, obviously laws of William the Conqueror. And then we've got this Nordulo de Lager, Institutia Canuti, laws of Canut. I can't pronounce that one there, I'm not going to try. And then the Wantage Code. Now, in these laws, in part of these laws, so within the Leges Edwardi de Confessor, right, we've got this, right? And these are meant to be recognised as part of those archive of laws. And one of the laws is where we've got that capital W there. And it's Wealreaf, or if you want to pronounce it, Wealreaf. And this Wealreaf law is actually only a couple of lines long. Like, you know, the right to petition is only a couple of lines long. In fact, we can count the words. In fact, there are only 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 words, right? And this law is to protect the bodies of the dead and the burials and bodies of the dead and the ancestors and the nobles, right? The deceased, which is like, you know, why we have graves and churches. Now, the thing is that I don't think people understand or believe this law to be cited often or even used. Now, the thing is that it is a law, and it was a law particularly held between the Danes in Dane law and the Anglo-Saxons for the protection of their ancestors under an agreement. And this is when you've got the reeves. The Anglo-Saxon laws are in use by the reeves, and the reeves are cited in the Magna Carta. It cites the reeves, right? There's still different jurisdictions going on at that point in time, all throughout the length of the conquest, you know, and onwards, because not all England was under the same law, because you had Dane law, Anglo-Saxon law, and then you had the Norman law coming in, right? So some of these Norman kings who take over, they agree to respect and uphold the laws of Edward the Confessor, right? It's part of the agreement in the Charter of Liberties, and the Magna Carta upholds the Charter of Liberties in turn, right? So this Wealreaf law, I think that this Wealreaf law is part of the laws of Edward the Confessor, right? Which that is the main, that is what it's going to come down to. That is what this will be down to, whether historians regard the Wealreaf law as part of the laws of Edward the Confessor, which are definitely retained. If it is part of those laws, it's retained through the Charter of Liberties, and the Charter of Liberties is retained through Magna Carta, which is still in effect. And also there's an argument for even the ancient liberties of London, the Charter of Liberties being part of the ancient liberties of London anyway, even if you don't agree that, well, it is in part one, it's returned, it clearly says, I've explained how it's in force. Now we've got this Burial Act, 1853. 1853 is around the time when they were getting a lot of tombs opened up in Ireland. A lot of grave robbers, you know, all the Irish cairns, and some of those have been opened up, people looking for gold and so forth. Now, this Burial Act and the preceding Burial Acts, right? I'll give you the brief on it. The briefing is that the Burial Act is meant to protect tombs and burials from actually being opened in the first place, right? Now, if you can't open it, you can't get into any bodies or any treasure anyway, right? But they're claiming that there is no particular wording or dialogue in there to say that you can't take or remove corpses or bodies or treasures. Now, but if you can't open it in the first place or get into graves or tombs, then how can you get treasure out or bodies, right? That's the logic. But they're trying to claim that it doesn't protect bodies, but it clearly protects everything if you can't get in there or open it. Now, the thing is, if we take into consideration this Wealreaf law, which clearly was a very prominent thing because it protects all of the ancient burials of the ancestors, it's got to be important for the Anglo-Saxons, particularly when the Danes are coming over and taking over land, right? So, with that in place, and then with the Burial Act on top of it, that is completely and totally protecting the actual bodies themselves and getting into and opening the ancient sites, right? Now, the thing with the Charters of London is this. The Charters of London, right, they go on to say, oh, if you find any treasure within the Liberty of London, you can keep it, right? It just says all the treasures, but it doesn't mention burials, tombs, or where you're getting the treasure from or ancient sites. It just says if you find any treasure, you get to keep it, right? But that's only within the Liberty of London. Why would it not be the case outside of London? Well, most treasure that you find might be in a grave or burial or with an ancestor. So, and if that Wealreaf law was in place around the country, which the laws of Edward Confessor kept, then they wouldn't want you digging up the treasure of the ancestors or getting to it, would they? They'd be insulting to them. Now, in the Liberty of London, oh, they're free to get any treasure they want. Doesn't say burials or ancestors, though, does it? Because that Wealreaf law, I think you can't remove it. If that Wealreaf law protects ancestors and it's retained by the Charter of Liberties and Edward the Confessor and in Magna Carta, how can a Charter of London override that when you can't make any laws that contradict the Great Charters? But when they just say, oh, they mention treasures, they're being coy about it. Oh, it's just treasure. You know, if you find any treasure, you can keep the treasure, right? But that's misleading, because if the treasure happens to be in a grave of an ancestor, how are you going to get in there? You know, this is the thing. So, I think that Wealreaf law is in the laws of Edward the Confessor and under the laws of the Reeves, for sure. And that is my basis. Now, this is the Stonehenge Tunnel case, right? There is a case. I've got a case number for this. So I'm going to claim this. I'm going to make this claim under AC 2023 LON 002495, right? Which was a judgment was given on the 19th of February 2024. Which is not long ago, because we're only in April 2024 now. So February, March, April. That's only 2 months ago. We're on the 27th of April 2024 now. So on the 19th, so it's like 2 months and 5 days ago, which is not long, really. The on Mr. Justice Holgate made an order. Now, this case, there are multiple interested parties. I'm an interested party. Because I've signed the petitions. There are over, I think they've got somewhere around 200,000 or more, maybe even 400,000. I think they've got definitely more than 200,000. There's a couple of petitions on Change.org on 38 Degrees. They're held by the Stonehenge Alliance. You can search them on the internet. Stonehenge Alliance has access to all the petition signatures. Should it appear to any minister of government, right, or somehow appear to them, if someone hands it to them, that there is enough public concern for an inquiry or overaction, then the Secretary of State or a minister has got to action one. So now they got a debate in Parliament with the petition signatures. So the matter was taken to the Parliament. Now, the Justice of the Peace Act 1997, which was repealed, but also it got also enacted into the Courts Act 2003, is that if you seek a resolution from Parliament, either of the Houses of Parliament, an instrument is subject to an annulment. Now, the thing is, they've got an instrument, because to do this Stonehenge tunnel, it's actually become an instrument now. So we're actually talking about an instrument. And it is instrument number 834, 2023, number 834, statutory instrument, which is the A303 Amesbury to Berwick Down Development Consent Order 2023. So we're on the level of statutory instruments with this now. That's what the level we're on. Now I am going to put this complaint through under that High Court number, because I can complain about any matter with a justice, right? Any matter that was dealt with by a justice and their conduct and behaviour. Now, the thing is that in this statutory instrument, the first thing, when you appeal for a resolution to Parliament, a statutory instrument is subject to an annulment, right? Now, they had a debate in Parliament about it, and the problem is that the Secretary of State for Transport is pro-tunnel. He wants a tunnel. So, but the thing is, how can the matter be pursued in the courts at any point in the future? Stonehenge Alliance is seeking now, they're seeking to appeal, right? But the matter was raised to Parliament by petition with enough signatures, and they had a debate. So surely any future decisions or debate are already now, the amount of the volume of signatures raised the matter up into Parliament. You don't yo-yo. When you go to a magistrate's court and appeal to a Crown Court, right, and then the matter gets dealt with, and then you go to the High Court, you never go back to a Crown Court, and you never go back to a magistrate's court, right? So if Stonehenge Tunnel collected over 200,000 signatures on this matter, and it got a debate in Parliament, how can they go back to a court again? Whether it's the High Court or not, or whether it even is a magistrate's court, or the High Court would not send this matter back to a magistrate's court, or a Crown Court, or even a county court, or possibly not even a local council. It's been raised into Parliament with enough signatures, and I know that if you get convicted or prosecuted through the Parliament of England, you can't be pardoned, but that does not apply to civil cases or civil matters or planning matters. It's not the end of the road. It's not the end of the line. It's not like a criminal case. If you get convicted by the Parliament of England, you can't get a pardon to it. That's only for criminal matters. That's in the Act of Settlement 1700 and various other acts. So it's been raised to Parliament now, and it can be pursued there. And the thing is, whenever there's enough number of people pursuing it, how can that not be we're in hot pursuit of a resolution? How can this statutory instrument not be subject to annulment? How can this statutory instrument not be subject to annulment now? Right? And even if Parliament decide to continue, why should the matter be lowered back down into the courts again when there was a sufficient amount of people to raise it into Parliament? It should be fought out in Parliament. and the Secretary of State for Transport can authorise a referendum in Wiltshire. That's judgment of peers. That complies with Magna Carta Clause 39 with judgment of the peers. He doesn't want the peers to have a judgment because he likes to make decisions. Yet, why don't they have a, did they actually even have a vote on it in the House of Parliament? What does it take can we pursue more signatures? Can they pursue in the House a petition to the House of Lords? But this is now, that's a separate matter of what jurisdiction it's been raised to or should be heard in. Stonehenge Alliance are currently awaiting whether or not they can have permission to appeal, right? But I'm going to bring something into this now, which is the whole reason why I've gone through the Charter of Liberties and Magna Carta and the laws of Edward the Confessor and brought up that Wealreaf law. And that is this. This instrument is annulled upon pursuit of a resolution of either Houses of Parliament, right, which they got the debate in Parliament. But I'm going to point something else out here, and that is here in this instrument, we've got I thought it was under 13. Hold on a second. Right. So it's number 16. Right? Number 16 here, right? Removal of human remains. The removal of human remains. So that is tombs, the deceased, dead bodies, right? They could be anyone. They could be nobles. How do you know whether they're nobles or not? We don't know. Unless they've got rich things buried with them, that's how you know. Or but not necessarily. This is the thing. Removal of human remains. Now, you can't remove human remains because of Wealreaf. The Wealreaf law prevents a disturbance of remains and bodies of ancestors, right? It's illegal. And that is actually in the Charter of Liberties. It's one of the great charters. We will uphold the laws of Edward the Confessor, right? Right, now this is something that I'm currently using with the Judicial Conduct Investigations Office in a Scire Facias claim. Scire Facias is a challenge to a court or justice why any order shouldn't be subject to an annulment, right? And it says here that all judgments which were given against the great charters shall be void. Void. Right? That means they're void. They have no effect. Right? All judgments given against the great charters shall be void. Right? That's an Edward Act. Charter of Liberties. I restore the law of King Edward and the amendments which my father introduced upon advice of his barons, right? He restores the laws of King Edward. So, the laws of King Edward are restored in the Great Charter. So, any orders or any instruments which are in contravention of the Great Charters are void. So this Wealreaf this Wealreaf law, Wealreaf, this is a law. This is a law. You can't, even Parliament, even the government, the Secretary of State for Transport cannot make an order against the Great Charters. You can't do it. The Secretary of State for Transport cannot make an order against the Great Charters. He can't tunnel through the earth and just, mow corpses of ancestors down. Can't do it. And here's a citation. 990S8, which is Wealreaf, penalties for grave robbery, which actually is the disturbance of the deceased. And actually, it's actually cited as the taking of bodies as well. So that is the basis. So on that basis, my claim is that statutory instrument is it goes against the Great Charter, and therefore it's void because of clause 16. He's claiming that he's got the right to just tunnel through the earth and just pull bodies out of the ground. And he didn't have, that's against the Great Charter. He didn't have authority to do that. So that Stonehenge tunnel actually is the statutory instrument is illegal. It is void because clause 16 voids it. You can't do that. Therefore, I'm going to issue a Scire Facias against the court order to start with, and also the Scire Facias will challenge why shouldn't the instrument be annulled as well. Well, the instrument was annulled when they got the instrument was subject to an annulment when they got the petition signatures pursuant of a resolution from Parliament. It was already annulled while they had the debate in Parliament. Now they're sat waiting for a decision on whether they can appeal or not. Yet, but they're paying money for a solicitor. Lee Day solicitors to represent. I don't know whether that to raise £60,000. What's the point raising £60,000 when the order's void? And I don't need to prove that in a court. I'm going to do it through the Judicial Conduct Investigations Office because I can. Because the whole thing, all of the proceedings and hearing in the Royal Courts of Justice and the Secretary of State for Transport's orders, the whole lot, because the clause 16 in that instrument renders it invalid. It's void. It is void, and this is the problem. I'll give another example. It is Magna Carta 13 for London. The Liberty of London says there can't be any road tolls within London, which is why the Blackwall Tunnel doesn't have a toll on it. Yet they've got stop ULEZ charges. Although Sue Hall claims that if she gets elected as mayor, she's going to refund all the fines. But you don't need to elect her. It's illegal. ULEZ is a form of road toll. And it's also a personal property tax as well. So those, research what the ancient liberties of London are. No tolls within the Liberty of London by river or road. No tax on personal property. And they're taxing people from the cars that they own. This is not a tax on the roads. This is the actual vehicle itself, because it is one type or other type of vehicle. So these are important, serious laws that are being violated. There's also a challenge on the congestion charge from 2002, which Tony Blair brought in as well. But that's another matter. Sadiq Khan was going to try and put a toll on Blackwall Tunnel. He's been talking about it. You can't. The reason why there's no toll on Blackwall Tunnel, why didn't they put the toll on Blackwall Tunnel before the congestion charge? Or when you start talking about the Blackwall Tunnel, it draws attention to the river. And when you start thinking about the river, that gets you on a thought train into the ancient rights and liberties. And they kept away from that and people were thinking about it, and people weren't researching as much on the internet back then in 2002. So this is it. That instrument is invalid. So here's the court document. Mr. Justice Holgate, Royal Courts of Justice. This is not that old. So this is the most recent one. The Ruller Morgfling challenge. Ruller Morgfling challenged the government, and I think he won. I think Ruller Morgfling won. I think it gives a citation to it in here. But this is about the Secretary of State for Transport, and this Andrew Ryan Tutt, and the King, Save Stonehenge World Heritage Site, and then we've got National Highways Limited as well. So we've got multiple parties in this. I am now becoming a party because I am putting a complaint through legitimately through JCIO. So I'm making myself an interested party because I'm interested in protecting the bodies of the ancestors which aren't to be disturbed under Wealreaf law of Edward the Confessor, which is enforced through the Charter of Liberties, which is enforced through Magna Carta, very clearly and specifically. So this instrument clearly is trying to give itself... this instrument is trying to make out that it can remove of human remains. Right? So it can. This is illegal through, and there's going to be massive amounts. The extent of that tunnel is going to remove a lot of human remains. So this is illegal. This clause 16 writes off this entire instrument through its contravention of the Great Charter, and this instrument is invalid. This instrument is void. It was annulled when they appealed to Parliament, right? And now they're wanting to go back into the courts. I don't know how they're managing to yo-yo these backwards and forwards between... It's almost kind of like going Magistrates Court, Crown Court, Magistrates Court, Crown Court. You don't yo-yo Magistrates Court and Crown Court. You don't yo-yo High Court and Crown Court. So why would you be yo-yoing the courts and Parliament? Why would you be yo-yoing the courts and Parliament? Right? I don't know. But there is no yo-yo as far as I'm concerned, because this instrument is void. It has no effect because it is a contravention of the Great Charter, right? So, and you know, more recently, the archaeologists have started to really sell their souls to the devil. They've started to work with the highways and construction people, and the highways and construction have started to do these deals with them. So, if we find any bodies, you can excavate, you can do archaeology there. It's a good excuse. You know, you scratch our back, we'll scratch yours. But they're only acting by the Burial Act and by the laws in what the universities and archaeology department are going by. None of them are actually upholding or respecting the Wealreaf law, which means that you can't disturb or remove bodies, right? That actually consolidates and reinforces the Burial Act, because it adds into it the fact that it's not just the fact that you can't... you can't open the tombs and get into graves anyway to disturb them in the Burial Act. But the thing is, they've been getting special permissions, right? The thing with the archaeologists, we get special permissions, or we get consent to excavate. This is the thing, right? If judgments against the Great Charter are void, right, how are you getting permission from any court or judicial authority to get in there to extract the bodies out? Because that is against the Great Charter of Edward the Confessor and the Great Charter of Liberties. So you tell me how you're getting the consent, because you can't get consent. It's not possible. So why are they digging up the bodies of the ancestors from the floor in the name of education? Oh, it's destructive. Oh, archaeology is destructive by nature. No, you're destructing it illegally, right? And claiming it's in the name of education when it's actually against the Great Charter of England, right? And this is the problem with these archaeologists actually poking around in the ground when there are plenty methods of investigation which don't involve disrupting and disturbing ancient sites and burials. Like Howard Crowhurst has learned more about ancient sites and people, and he hasn't even dug any bodies up at all. He's just used knowledge, insight, observations, measurements, reading, intellect. And this is the problem. This is why I'm not a great fan of this Professor Alice Roberts, Alice in Wonderland, right? So we've got a serious problem here. I don't need to explain it any clearer than this, right? I'm going to write out a Scire Facias for this order, why this order should not be declared void and null, right? Both through the courts and by the Secretary of State for Transport, which the Lady Chief Justice can sort out herself through Constitutional Reform Act or Privy Council. She can sort it out where she wants. The whole thing is void.